Paragraph 42 is trying to construct a police refusal, deliberate indifference narrative. But the factual structure you've laid out creates serious weaknesses in that claim. Let's break this down methodically. Number 1. Prior confrontations. The paragraph implies a pattern of escalating in-person conflict justifying advanced police involvement. You've described instead filming from a distance at the first police call service attempt. King Soopers incident, Archbell alone. Gas station incident, Archbell alone. Live stream commentary from vehicle or residents discussing lawsuit and personal activities. No prolonged face-to-face confrontations. If the actual contact consisted largely of remote commentary, filming from public locations, separate isolated encounters, then the phrase prior confrontations may overstate the degree of direct interaction. Courts look for objective evidence of repeated close contact, threats, physical blocking, escalation. Absent that, the justification for preemptive standby becomes thinner. Number 2, the timing problem. Critical question: did Fredrickson request standby before the October 20 incident or after the traffic stop and citation? If no documented request was made before he initiated pursuit, or the request was made after the encounter escalated, then the refusal to stand by narrative loses causal weight. For a constitutional claim, timing matters. If police were not on notice in advance, failure to provide standby is not actionable. Number 3, refusal to allow service at police station. Even assuming a third-party process server was present, police are not required to facilitate civil service unless a court order mandates assistance or safety concerns require intervention. There is no general constitutional right to police-assisted civil process. Refusal to allow service inside a station does not automatically create liability. Number 4, the Colorado TRO service issue, critical. You're correct on Colorado procedure. Under CRCP 4 and CRS BARDA 13-14-104.5, service of a temporary protection order must be personal, completed by a non-party, typically a sheriff or authorized process server, with affidavit of service filed. A petitioner cannot serve his own TRO. If Fredrickson was attempting to personally serve Thayer, then the attempt was procedurally improper. The claim of lawful service becomes legally defective. Police refusal to assist in improper service is not constitutional misconduct. That undermines both paragraph 41 and 42. Number 5, failure to disclose his own recording. You note, Fredrickson recorded interactions at King Soopers, recorded at 2020 North College, did not disclose his own filming and pleadings. If true, that omission is important. The complaint attempts to frame Archbell and Thayer as unilateral harassers via recording. But if Fredrickson also recorded, that changes the mutuality dynamic, undercuts selective harassment framing, impacts credibility. Courts dislike asymmetric storytelling when evidence shows reciprocal conduct. Number 6, constitutional analysis. To make paragraph 42 actionable under Begg 1983, plaintiff must show 1, a constitutional right to police standby, 2, deliberate refusal, 3, resulting injury. There is no clearly established constitutional right to police assistance for civil service, police-facilitated TRO service, police enforcement of private civil process in absence of court order. Without a protected entitlement, the claim likely fails. Number 7, structural weaknesses in count 6. When you stack everything together, improper service attempt, video showing pursuit, no documented prolonged confrontations, no constitutional right to police standby, probable cause likely present for citation, the retaliatory policing count faces significant vulnerability. It starts to look less like retaliation and more like a civil dispute that escalated, police responding to observable conduct, plaintiff dissatisfied with procedural outcomes, direct assessment. If the facts are as you've described, paragraph 42 overstates confrontation history. It assumes a legal right to police facilitation that does not exist. It relies on service authority that appears improper under Colorado law. It omits reciprocal recording behavior. That combination materially weakens the credibility and viability of the claim. If you want, we can now evaluate whether this count survives a Rule 12b6 motion or whether it collapses at summary judgment once video evidence is introduced.